minute early, but we are ready. Ready to rock and roll. So, morning, Radie.
Good morning.
Nice to have you with me. Finally meet you as well after all of this time. We're backwards and forwards on email and WhatsApp. Thanks to Sharon King for getting me in touch with Radie Botha of Mooney Ford and Partners.
Mooney Ford and Partners,
yeah. And they are upstairs in the building above us, which is why I said to Radie, let's meet here at Shoots and Leaves. It's nice and easy, and they've got delicious bluebird coffee.
Very good coffee, yes.
Yeah, delicious coffee. So we are going to chat a little bit about sectional title today, and Radie and I were just chatting with some great stories now. So hopefully we can entertain you with a few questions and answers. If you've got any questions, just pop them through on there. I'll have to put my glasses on so I can actually see that far. There we go. Oh, Mooney Fords have joined already. There we go. So your marketing department's working well. Okay, so just to start with, we're going to discuss the basics of sectional title today, very basic and simple, relating to owners selling their property, obviously agents, what we need to do in order to get the property marketed and sold, and then also what tenants' rights are, very basic in that sale process, if there are tenants in a property, which 9 out of 10 times there are.
Quite often, yeah.
Okay, so just in a nutshell, that's where we're headed. So I just want to start with, in our footstoots clause in our sale agreement at Remax Panache, I'm not sure if it's in everybody else's sale agreements, but it should be. There is a clause in there that mentions management rules, conduct rules, and homeowners association rules. Please can you briefly explain what those are and why they would be in the sale agreement?
Yeah, so every body corporate will have a set of management rules and conduct rules, and it deals with the sort of the running of the body corporate. They differ slightly in that the management rules will deal with the more serious issues, whether the number of trustees, also the procedural requirements for running of the body corporate.
Okay.
And that can be anything from your trustees, your number of trustees, limits on trustees, spending, etc. Whereas your conduct rules would be, so the management rules would be the what, the why, and the how.
Okay.
And your conduct rules would be the do's and the don'ts. So it'll be, it'll regulate the relationship between your occupants and your owners and your tenants. So, anything from parking to all the do's and the don'ts. Don't do this on a Saturday. Don't do this to recycling.
And when people can move into the complex, when they can move out, and what days and times.
The dates and times that they can do sort of a bit of work or construction on as well. Builders, all of that. Basically.
Yeah, because I see some complexes also have minimum or maximum tonnage allowed for moving vehicles.
Yes,
so they might be moving in a big 4-ton truck, but then they get to the complex and they have to move in and out with a 1-ton truck.
100%.
So that's one of those, and then also moving, Monday to Friday, not on weekends.
And these rules can, really be about pretty much anything. Because all bodies corporates are unique. Some might have golf courses, some have frail care facilities, some have beaches or beach access, dams, koi ponds, you name it.
Yes.
So because each one is unique, the Sectional Title Schemes Management Act, which is a mouthful, so we just call it the STSMA, that it gives bodies corporate or trustees and also developers relative freedom in the making and also the amendment of these rules to suit each and every body corporate.
Yes.
And also, as needs evolve for each body corporate, also to then, like I said, amend those rules to keep them up to date. And like I said, they could be literally about anything, from pets to parking to recycling to swimming to skinny dipping, whatever you want to do.
Because some complexes, talking about pets and parking and children and that, there's some complexes have got signs up there, drive slowly children around, and some people are no skateboarding because there's children.
No skateboarding, no biking, like I say.
So some are a little bit more lenient than others, but 100%. Again, it depends.
And again, it depends on each body corporate and their needs and their requirements. So, the pets that I touched on, so my complex, for example, where I live in Snowty, we're not allowed any pets.
Okay.
We are situated next to an estuary. We've got a lot of wildlife there.
Okay.
There's from mongoose to duikers to monkeys to snakes,
Yes.
And so we are not allowed to have pets because they interfere with that ecosystem.
Okay.
And when I mentioned earlier that you've got a relative freedom about the rules that you want to make for the body corporate, as long as they are within limits, but as long as they are reasonable and you can justify the reasonableness of those rules if they're challenged, and as long as they apply equally to all owners, they should pretty much be accepted.
Yes.
So, we can't have rules that say, I can swim on Saturdays and you on Sundays. That's not, we don't apply them equally or reasonable for that matter.
Yeah.
But so, for example, the pets at my complex, it's reasonable for us not to have
because
pets.
You've got the
because
wildlife.
We've got the wildlife.
Yes.
You might live in a complex that's got no wildlife, wide open spaces, perfect for dogs. It might not be reasonable in your body corporate to not allow pets, for example.
Okay. And that's why in most apartment buildings as well, I imagine that they don't allow pets because there's no freedom for them to roam around.
Size limit perhaps on the pet, like just a small little
dog, yes, normally under 10 kgs or something.
Exactly.
So very important for people to see those rules before they even sign the offer to purchase.
It is so crucial. And I mean, people come to see me to consult with me, and it's a bit of a cliche, but nobody ever comes to see me to say things are going so well. It's always, I've got a problem, fix the problem, please.
Yes,
and a lot of those problems actually could have been prevented or could have been fixed much earlier on in the process if they saw or read or considered those rules before buying into the complex. Because whether or not you've read them, you've seen them, you even know about them, if you buy into the complex, you bind yourself to those rules, whether or not you know about them.
Yes.
So after the fact, you could now be fined or told you're not allowed your pets, for example, because you weren't aware of those rules.
Aware of those rules,
Exactly.
yeah. So basically, as agents, we should be, when we're getting the mandate, we should make sure we're getting all the management rules, conduct rules, homeowners association rules if there are, and then I always ask for the financials of the body corporates because I know the bank will need that down the line for the bond application. So I try and get all of that up front.
Absolutely.
Not always very easy to get from the managing agent.
There's always a bit of a back and forth to get that done.
Yes.
But the financials are important because you want to reassure your buyers that they're buying into a well-run body corporate. Not somebody where there's a special levy of 10, 20 grand every month because they have to fix this or have to fix that.
Yes.
So that that it's well run basically.
So, sorry, you touched on a levy there, and a special levy. So again, in our sale agreement, we've got approximate rates that might be payable each month, and then also the approximate levies that are payable each month, and that's stipulated in the sale agreement up front. And a lot of people in sectional title aren't aware that you are paying levies. And then there's a special levy perhaps sometimes. And then what happens with complexes within estates, for example, within Kindlewood or in Mount Edgecombe, there's sectional title development. So then they have double levies because they have an estate levy plus then the sectional title complex levy. So people aren't always aware of that until it gets time to signing the agreement, or they don't understand it. And then that's where they probably come to you down the line as well. Yes.
So no, that's so important. It's so good that you have that in your agreements because it sounds obvious when you talk about it. There's a levy in a sectional title development, but I've seen owners before where when they come to budgeting now for the new property, they obviously budget for the bond, the rates, the water, electricity, whatever, but they don't necessarily think about the levy that will be there as well. And then they buy into a property, and then suddenly there's this extra 2,500, 3,000 rand monthly expense over and above your bond, your rates, etc. And you budget for your bond, you sort of try and look at the upper edge of the bond so you can buy a nicer place. Now you are budgeting yourself out of paying for levies a month as well. And the problem with that comes in there is where a body corporate is not they don't budget to make a profit.
No.
They budget for what they think their expenses might be every year in advance. So if one owner doesn't pay their levies, the body corporate is now running at a loss because there are just one levy less per month, something that they can't pay for. And if enough owners don't pay their levies, it can cripple a body corporate.
Then that's where you see buildings falling into disrepair.
Exactly, yeah.
Okay. So briefly, what does a levy cover though?
So again, it depends, but at the AGM for every year, you will, or the trustees will work out the budget for the upcoming year, and they will think, we'll have to pay everything. They must actually think of all the expenses that they might have, and then they budget for that, and then obviously each the owners will contribute that on a monthly basis. It's actually an annual levy that you are billed in advance, or that's payable in advance. But bodies corporate normally just let you or allow you to pay it off monthly as you go. But it's for actually absolutely every expense. And the problem when I mentioned bodies corporate that are run properly is that if there's a big expense that they didn't budget for, that they weren't aware of.
Yes.
Now they still need to pay for that.
Yes.
So the owners are going to be on the hook for that. They raise a special levy of however much, and that could be suddenly all out of the blue. Each owner needs to pay an extra 5,000 rand, extra 10,000 rand for whatever the case may be, unbudgeted for expense.
Expense, yes. Yeah. And then obviously in that event, they would call a special meeting, and obviously,
well, for
or not necessarily.
Levy, not so much. No, a special levy, the trustees can just say, right, guys, we need
X
$1 million
amount
for painting,
and
this is your special levy, and it's payable next month.
Okay.
And you can sort of try and negotiate and say, listen, guys, can I, but if it's an urgent expense, they need that money.
It needs to be done. Oh, okay, wow. So a couple of years ago, just help me along here if you don't mind, there was that whole thing where body corporates had to have funding for 10 years or something.
Yes,
so that special levies wouldn't be formed. Is that a thing now? How does that operate?
Your 10-year maintenance, repair and replacement plan.
Yes.
So you've got to, it's very complicated. Even I sometimes still struggle to understand.
Okay, sorry.
But it basically, like you say, they're trying to minimize special levies going forward.
Okay.
So you try and almost budget in advance for certain expenses that you might come in 5 years, 10 years time.
Okay.
And some trustees thumbsuck that and sort of say, we'll just chuck some money at the problem. Mm-hmm. But if you can afford it, you must get somebody out to come and actually look at everything and give you an accurate sort of budgeted expense, future expense for that.
Okay.
And it, like I said, it is for unbudgeted, it's almost like to budget for unbudgeted expenses going forward, and then to try and minimize special levies going forward. But now, obviously, you start at zero with this with this plan, or this fund rather. So there's a bit of an extra expense in the beginning where you've got to sort of fund this, but in the long run, it's going to save the owners money, because there will be that sort of that reserve built up.
Yeah.
For those
so maybe
expenses.
that's why in some statements they've got like a reserve levy extra that's just going into that reserve fund for that 10-year plan.
I studied law because I can't do maths, but one of the things where there's a very specific, like a mathematical equation where you have to, if the reserve for this year is a certain percentage of the budgeted for the next year, etc., then you must a certain minimum amount must be budgeted for that maintenance plan for the following year until you get that reserves properly built up. So there might very well be a normal levy, your CSOS levy, and then just a little bit of extra like repair plan levy.
Okay, perfect. But that's where managing agents and the body corporate themselves actually deal with that.
Yeah.
And any owner can go on to, or any owner becomes a trustee, but then if they want to become
not a trustee, but they become a member of the body corporate.
A member of the body corporate, okay. And then if they want to go and become a trustee, then obviously they have to be nominated.
At the AGM, you do nominations, get elected, and it's a thankless job. Honestly, it's something I've managed to avoid at my body corporate where I live, because it's very well run. The trustees are great.
Yes.
But it's a thankless job, and it's lay people. It's not attorneys.
It's normal people. Yes, because everyone's living in the complex technically.
Exactly. You live there, and you've got to adhere to all these laws and rules and regulations, and you also have to do it after hours on weekends in your spare time, because you've got jobs.
Yes.
And then there's always one or two people who aren't satisfied with what you do, so there will be complaints and that type of thing.
Yes.
So it's a thankless job, and I take my hat off to those people, and I'm trying to avoid becoming a trustee myself.
Okay, you briefly touched on the CSOS levy. Can we just quickly discuss what CSOS is? Because I've had one or two issues with CSOS for clients of late. So if you can just touch on that and give an example.
It's the Community Schemes Ombud Service, or basically the ombudsman for sectional title and sectional title developments. Many sectors have an ombudsman, whether it's banking or finance or whatever the case may be. So this will be specifically for sectional title schemes, and it's a dispute resolution. Well, they do more than that, but mainly what I deal with them is the dispute resolution aspect of that. So. Yes, you can run to court if you're an owner or the trustees. You could run to court for whatever problem you have, but this is almost a way for them to.
Sorry, just
for them to create a bit of a barrier between the
that's perfect.
litigants and the courts, where you can approach CSOS instead, and you can they're quite jacked up. You can go on the website, you can download all the forms there. And then you can, if you have a complaint as a body corporate, as a trustee, as an owner, whatever the case may be, you lodge your complaint there. They will send it to the other side. They'll get all the information. There'll be some affidavits, well, not even affidavits, but it's much more informal.
Yeah.
We'll have information exchange, and then you will have a conciliation meeting or a hearing where you all sit around a table, and it's like a, can't we all just get along type of thing.
Yes.
That often fails, unfortunately, and then you go to adjudication, where CSIS will appoint an adjudicator, which is often an advocate or an attorney with a certain amount of years experience in sectional title, and then they will hear the matter and then make a ruling on.
Make a ruling,
on
yeah.
that,
And the process is fairly quick from what I've gathered.
Yes, yeah. So there was obviously during COVID there was a bit of a delay with these things.
Yes.
But the good thing there is that they started then first to do Zoom conciliation and then adjudication hearings.
Yes.
And nowadays there's a practice directive where they sometimes don't even have a proper hearing. They get all the information to the adjudicator, who will simply read it and then make a ruling and then sort of publish his ruling.
Wow.
Which not ideal. Sometimes you want to be able to change someone's mind.
Yes.
You want to be sort of do a bit of attorney's work there. Although attorneys are actually not allowed at the adjudication hearings unless both parties agree that attorneys could be allowed, or if the adjudicator thinks that the subject matter is sufficiently complicated to warrant an attorney being there as well.
Okay, so it really is possibly two owners within a complex just discussing and fighting it out for whatever the reason is.
Yeah. But so CSIS will facilitate that, and they will make the ruling. And you can always go and appeal to court if you're not satisfied with the ruling, or you could go and make that ruling an order of court if you wanted to. But generally speaking, once there's a ruling has been made, people sort of like, okay, fine.
And really, everybody's trying to just maintain good neighbours at the end of the day, and hope that everybody in the complex gets along. Yeah.
And that's such an important thing when you live in a complex, because you get the benefits like security, for example, or somebody pays for or runs the body corporate itself. But then you also have to, there's give and take. You've got to give. I live very close to my neighbour, or this person is in my face more than I would like them to be, but that's where they live, unfortunately.
Yeah, so that's where the noise levels and all those things come in.
So often, so many disputes can be settled with just common sense prevailing. Just a bit of give and take. It's fine. Don't run to court because this guy is revving his Harley in the morning when he's leaving for work.
Yeah. Okay, just quickly, in terms of selling a property, I was sent this question a week or two back in terms of tenants' rights when selling, and an agent coming in, and how we market a property is we take photos and we do video, and we obviously have a mandate from the seller to sell the property. So there were two questions in there. One was the tenant was very unhappy to have all of her personal belongings and her furniture in the photos. So how do you then market a property when you can't take photos and you're only taking photos of the outside of the building? And secondly, she said that her lease was only up at the end of February. So why is the seller putting the house on the market now, and why does she have to allow people access now? So if you could just help me with those two.
So the furniture thing is, you sent me the question and I thought, geez, I've never actually dealt with this before. It seems a bit unreasonable.
Actually, it's happened to me once before, a few years ago in a house. So this is the second time it's come up.
I thought it was unreasonable, and I spoke to some people and said, you might not want people to see you've got a 60-inch TV there that
Yes.
So I would always try and revert back to the lease agreement, So, and lease agreements, again, it's something that I've been dealing with more and more, lease disputes, rental disputes. But always try, and I've seen lease agreements that are half a page long, and I've got commercial lease agreements that are 70 pages long, so they come in all shapes and sizes.
Yes.
And you try and always revert back to the lease agreement, so you would try and work that in the beginning into your lease agreement to say, and normally there's provision for access by the landlord to the property with enough warning or notice. They can come and see the property or show somebody the property. Like I said, I've never come across somebody who had a problem with their furniture. But again, one, I would advise, if I was acting for the landlord, I would say work that into your lease agreement to say that we can come and take pictures. Whoever may have their
because I know when we do photos, we can also say to our photographer sometimes just block out the photos if there's any personal photos in a home and
like
that type of thing. So we do that generally.
Do you, as a tenant, want to move all your stuff into the garden so that they can take pictures? But then also, on the other hand, a landlord would ideally have pictures of the open space before the tenant comes in. So there's got to be a give and take and a bit of common sense there that should prevail. But ideally work it into the lease agreement so people from the beginning, you know exactly where you stand with all those issues.
And then in terms of selling and allowing access to people, because I know normally in most lease agreements it says in the last 2 months the landlord can market the property for lease or for sale, whichever they prefer. But in this instance it's obviously 4 months before the end of the lease. Again, is it just sort of the tenant and the landlord deciding?
Come together and common sense must prevail. But like I said, you can always work. It doesn't. I mean, each lease agreement is different. It could say in the last 2 months, last 6 months, last year. It could be any time. With good notice. But and obviously with the tenant might not be happy with someone selling the property with their tenant. And you've got the.
If they want to stay on and renew the lease.
Stay on, and of course then that's when one of the rare occasions when you can pull out some of the Roman Dutch law that you studied at varsity, where you got for quip, which means that if you're a tenant in my property and I sell the property, I sell it with the lease agreement in place.
Yes.
So the purchaser will buy it with the tenant in place. Often tenants don't want to stay on, which is fine, that they can obviously negotiate into that lease or early into the lease.
Yes.
But it's again, revert to the lease agreement and put as much in there as possible. From the beginning, you know where you stand with the other parts.
Perfect.
And then, like I said, common sense must prevail.
So just quickly to finish off, I know we discussed briefly units, sections, and common property. In terms of exclusive use, which is parking, for example. So could we just briefly touch on those? So I think most people and even attorneys are guilty of using the word section and unit sort of interchangeably, which and normally is fine. If I talk about my unit or my section, you know I'm talking about the property. But when it comes down to the sort of technicalities of it or litigating over something, then that's when you sort of need to differentiate. So your section, unit, common property. The official definition for section isn't very helpful because it simply says the section as described on your sectional title plans, which means what? But basically, if you can think of your, I almost said unit there as well. I mean section. Well, if you think of your property, your house, for example, everything inside the walls, the ceiling, and the floor, that almost like that inner shell, if I can call it that. You can try and visualize this. That is your section. The inner shell, the actual four walls.
Exactly inside of your property. That's your section. Now your unit would be, when it comes to conveyancing, would be what you actually sell in terms of the OTP and to the transfer, because your unit is your section plus your undivided share in the common property. So each owner, just by being an owner in the property, owns a section of the common property. But
that being passageways,
it could be anything.
Driveway.
So I mean, in a block of flats, it could be the lifts, the landings, the basement, whatever else is there, the parking. Where in a complex, it'll be the boundary walls, the park, everything not forming part of a section. Will be common property. So, and as an owner, you own an undivided share, which I'll touch on now as well. But basically, if you think of your section, the common property is everything else. So, which includes the outer layer of your house, basically. So, if you think about it, you don't own the outer brick layer of your house. It's if you think of your section, it's almost covered in a blanket of common property, if you want to look at it that way.
So that's why the painting would be done by the body corporate, because that's external.
So that's how it benefits owners, is that just, you think, I don't own the outer layer of my house. But it's not your responsibility to fix or to paint, for example. So while you can paint, drive, nails, alter, whatever you want to do on the inside of your house, your section, you can't technically or practically speaking do that on the outside. I mean,
without permission.
Without permission, exactly. So, but I mean, it's a bit of fast and loose, the people, because I mean, if you want to hang your live, laugh, love sign on the front of your door, you're not going to ask the body corporatist, can I drive this nail into the wall? But anything more than that, and that's when the painting, like you said, comes in. It's not, I mean, indirectly as an owner you pay for the painting through your levies, or maybe even a special levy, but it's not your responsibility, it's not your expense, it's the body corporate expense. And also if something goes wrong, it's not your problem, the body corporate must fix it. If bricks are starting to fall out, they must fix it, they must pay for that.
Which is why some buildings look a little bit tatty after 6 or 7 years, just as they're about to start painting again. And then